Hello, everyone. Welcome to the Women's Property Tax Association's panel today, Regional Perspective on the Board of Review process, where we are here today with representatives from four different county board of reviews. Some housekeeping matters to start with is that we have been approved for MCLE credit for this presentation. And in order to obtain that, you need to fill out the evaluation survey at the at right after this presentation. You need to make sure that you are signed in under your unique link and provide your ARDC um, number in order to obtain that MCLE credit. The materials associated with this presentation were included in a downloadable link in the email registration link, but also it will be in the chat as well so that you can download it during this presentation. And then finally, if you have questions, those are being moderated and we will likely get to them at the end if there is time, unless they seamlessly come into fall into the presentation today. And with that, I'm going to do a brief introduction of who we have here with us today. So we have Michelle Abel, who is with the Kane County Board of Review. She is the Deputy Supervisor of Assessments. She has been a licensed real residential appraiser uh, since 2005 and has served in the past in the King County Board of Review as an alternate and appointed member, and is now currently serving as an appraiser specialist for the Supervisor of Assessment Office. Then we have Rebecca Bircher from the McHenry County Board of Review, and then she also serves as an alternate for the Lake County Board of Review. She has previously worked as a legal assistant in a law firm that handled property tax matters, so she has attended them and prepared for them on a attorney side, and now obviously sits on the Board of Review side as well. She also has her CIAO. And then we have Maria Helm, who is with the Lake County Board of Review. She is was an alternate member and now is one of the primary members on the Board of Review, an appointed member of the Board of Review. She also holds her CIAO and has worked in real estate for many years as well. And finally, we have Bridget Mackey, who is with the DuPage Board of Review. She's a counter supervisor of assessment analyst. She's been there for over 19 years and oversees Board of Review, manages all the appeals and for the Board of Review and the Property Tax Appeal Board, and is a primary point of contact. So if you've worked with Board of Review in DuPage County, you've probably interacted with her. Thank you all today for your participation. We are going to have a discussion today that kind of goes through the different processes and procedures before the board review and how they might be a little different from county to county. They are different in some ways from Cook, which I know we already had a presentation on the Cook County Board of Review. But going through that, I'm going to kick it off with some procedural or administrative aspects. So, as we know that there are different rules that the different boards of review adopt each year. And those are included in each board of review that is represented here today. The current board of review rules are included in the materials. So one thing that I know has been a hot topic lately, and it may or may not be new for your boards of review, but it's the issue of whether or not non-attorneys who are not pro se, so not obviously a pro se individual can represent themselves before the board of review, but someone who's not an attorney, whether that's an appraiser or some other individual, what do your boards rules and have they changed recently say regarding non-attorney filings? And I am going to go to Bridget first with DuPage County.
Yeah, so actually, we did just change that rule for our 2024 board review that only Illinois licensed attorneys can represent someone at the board review.
Okay. And Michelle, how is it in Kane County?
Same. We've had that for a while.
Okay. And Maria for Lake?
Had that for probably at least 12 years.
Okay. And then finally, Rebecca and McHenry?
We actually do allow non-attorney filings in McHenry County.
Okay. Now, um, as we just noted, Bridget, as you noticed in 2024, the rules changed. How is the rules, are they often updated every year for your counties? Is there a clear way for attorneys to know what changes are or different procedures? Are they small changes, or have there been years in the past where there have been um, large overhauls of the rules? I'll go in the same order again for this. Bridget, how does DuPage handle their board review rules?
So, when we did change the rules in 2024 with no longer allowing tax reps, we sent out a letter to every attorney letting them know that there had been a change in our rules. And I would think going forward, anything that would directly affect someone filing an appeal, we would send out a letter to all of our attorneys letting them know that this is our new rule.
Okay. Do anything in your rules, are there any other indications within your rules that it show the changes from year to year, or is it just more of a look and a comparing?
I think, well, we don't have our old rules published anywhere, so there'd be no
Okay.
compare back and forth. Um, when we have a meeting, obviously we do all the open meeting acts where it's an open meeting. You can come and be a part of the conversation if you'd like. Anytime all of our board members are meeting in that way.
Okay, great. Um, Michelle, how does Kane indicate changes in the rules from year to year?
Each year, they will highlight in yellow anything that's new to make it real easy to detect anything that's changed.
Okay. And those, when they are discussing their changes, are those also at public meetings? So if people had input on the rules, they'd be able to share that during public comment?
It's my understanding that it would be a public meeting. Yeah. Hmm.
Okay. And Maria, how does Lake indicate any changes from year to year from the rules?
We publish it online and give an opportunity, I think it's 30 days to provide any feedback or inquiries, which that's directed to the CCAO, and that will come up to us at a board meeting. And obviously for us, we rely heavily on the input of our state's attorneys as well, for giving us guidance, first of all, on constructing the rules and making any changes, to do that research for us. But beforehand, we want to always be kind of efficient with our standards and practices. So we do change quite a few things from year to year, particularly as things come up. So our rules have been, refined continuously over time. So.
Okay, great. And then Rebecca, anything unique with McHenry's rules as they change from year to year?
Indeed, this year our rules were very much overhauled. And we are expecting a potential number of changes next year as well. Um, I'm newly appointed to the Board of Review in McHenry, and so that is one of the things that we've worked on quite a bit. Of course, they are public meetings, and anyone is certainly invited to attend them. And we also confer with the state's attorney in regards to changes. At this time, there is not an easy way to see any changes from year to year. Also, our board rules do allow changes within the year. So, although we don't anticipate doing so unless it's something, really critical, it can change, they can change at any time.
Okay, thanks.
Mhm.
So moving on, this might be just an open kind of answer, but with the prior to COVID, people in a lot of counties could request either in-person hearings or phone hearings in some counties, and then COVID entered into remote hearings and Zoom. Um, I guess I just really wanted everyone to quickly jump in and say, is there any what are the appearance options for parties for board review hearings? Are there any that only require in person? Is there a preferred appearance option for the board of review? Just know if there's any like unique aspects.
In DuPage County, we only offer phone hearings or hearings on evidence.
And for on evidence, do you mean that would be
That would
a
be,
phone hearing for hearings on
oh, so
evidence?
phone hearings are our only in-person option.
Okay,
We don't have Zoom or an ability to have people come in. So it's
okay,
phone hearings or a will not attend.
okay.
In Lake County, we do letter, in-person, Zoom, and all of those formats are recorded as well.
Mm.
So, Open Meetings Act rules apply. In a letter hearing, the way we function, is that it's an open meeting, an assessor can appear if they want, and or the appellant, but they cannot openly participate in the discussion.
We did used to have in-person hearings, which I loved. Now we just have virtual hearings. So you can call in on a phone or you can call in Zoom and participate in a hearing that way. And then we have the other option for non-appearance, so to speak. We call it streamlined. So that would be just the board talking on evidence. Nobody shows up to that non-appearance.
In McHenry, we do indeed do in-person hearings still. We're the last bastions, it looks like, for that. We do also allow attendance via Zoom or phone. We also have a non-hearings option. If an attorney is unable to attend, I believe they have the right to change it to a non-hearing if they choose.
Okay, and I think if I recall correctly, and I haven't looked at their current rules, Will, which is not here tonight, but just as another Collar County, requires in-person hearings. So it's always good to know what the different options are when you're, especially when these hearings sometimes are occurring uh at the same, on the same day in different counties. Prior to the advent of Zoom, there were definitely days where I drove through like 5 different counties to attend a bunch of different hearings. Like to have a hearing in Lake in the morning and then have to be down in McHenry in the afternoon.
Hmm.
So, um, so let's speaking of hearings, and we talked about kind of attendance options and how one can appear. Um, What about decisions? Are your decisions rendered at the hearing? Does the board remember and be rendered meaning kind of where the board of review is going to decide? And then there's also the issue of when does the decision go out to start the appeal, the possibility of appeal process. So, Bridget, how does DuPage handle their decisions?
We send out our decisions at the end of the board season. So all 9 of our townships receive their decisions all at the same time.
Do
And it,
participants know during the hearing where the board review is thinking or where they ultimately landed?
no, we don't give out that
Okay,
information until the official letter is sent.
okay. And Michelle, how does Kane do it?
Yeah, Kane does it the same way after all the townships are done. Like last year, the final notices went out January 21st. However, you will know what the decision is at the end of your hearing, and you will know what the assessment figure is if they lower it.
And Maria, how does
We announce it
do
at the hearing, and immediately the board members put it into the system. So our dockets are handed to our staffers at the end of the day. They do cross-check our work. So sometimes it comes back to us if there's discrepancies. We have at least 2, sometimes 3 board members per hearing of any type. We never, do a solo appearance by a board member to do a hearing. That wouldn't really be a good thing. But that said, the letters, once all of the books are reconciled for 18 townships in Lake, those go out at the end of the season.
Okay. And Rebecca for McHenry.
In McHenry, you'll know the results at the end of the hearing, and our notices have traditionally been sent out at the end of February.
Okay, great, thank you. And then finally, before we switch to some of the evidentiary aspects, are there any policy shifts or valuation trends that your boards are seeing for 2025 that people should be aware of, or anything that your boards are putting specific focus on? Then we'll start with Bridget.
Nothing that I've noticed yet, but we're just starting our 2025 year, so
Yeah.
we're just beginning.
Michelle?
So there's no policy shifts, although there are some valuation trends for 2025 with industrial and multifamily residential being having pretty strong market presence. And then restaurants are doing a little better now than they were before. And then there's no special focus of anything right now that, although, I could have probably mentioned this with the rules. The board of review does spend a lot of time on their guidelines and their rules. They talk a lot about it, and it matters to them what other parties say also.
Maria?
I guess just we look at patterns from year to year, we're noticing a lot more equity cases coming in. So that's kind of been emphasized a little bit in our focus for analyzing those, as opposed to sales. And of course, sales in our county have been very strong. Related to that, sales ratio studies in the recent interval of years in this quad, township assessments have not really been up to the level that they should be, and assessors are going in and doing some neighborhood equalization. And so that is now part of the equation this year, a lot more we're seeing.
Good. And Rebecca, any trends you're seeing out in McHenry?
This is a little bit outside of that, but we have a new supervisor of assessments that started up a couple years ago, and Alex is wonderful. He has been at McHenry County for many, many years in a different role, but he is, changing a lot of the ways that McHenry County handles a lot of their commercial and industrial complaints. In the past, the supervisor of assessments was a lot more involved in that decision-making process. And Alex has been interested in the Board of Review taking a more forward role in making the decisions in regards to those situations.
Great. So Maria, you noted that equity and uniformity appeals are a little more popular this year. So just overall, when a petitioner or someone is making an equity or uniformity argument, what is the board review looking at when considering those overall?
Well, first and foremost, they have to be in the same neighborhood. We don't assemble, different neighborhoods in an equity appeal. As close as possible to mirror the subject, obviously, with AGLA being the other dominant feature or element that we're looking at. In our county, we have some unique areas of very old properties, some of which, a lot of those hug the shore of the lake. And they have 1800s for the original date of construction. And then the artificiality but necessity of an effective age isn't necessarily, 2025 improvement. So we always defer to the assessor. And clearly when we're in a live hearing, we have the opportunity to do that, to inquire a little bit more about what that effective age represents. How new is that, in reality to what's been done to the property? So effective age and age of the property, if there is no effective age involved, as close as possible within, a few years. But we've seen, equity appeals filed pro se and by attorneys where, the spread is about 10 or 15 years, and that doesn't work for us. We really want as close as possible to the same year or within, 5 years. to be reasonable as a good comp.
Great. And then I guess opening up to anyone else, does anyone else have other things that they want to add when they're considering an equity uniformity appeal in their county?
So in the Kane County Board rules, if it's an equity appeal and it's income producing property, the income and expense data of the property should be submitted as evidence also. And same as Lake, we actually don't accept comparables for equity complaints outside of Kane County. We'll see them every once in a while for really unusual commercial properties, but if the taxpayer or the attorney is going to provide evidence outside of Kane County and then the assessor provides evidence inside Kane County, then that'll get more weight.
Yeah, I certainly echo what Maria has talked about. And I do think that it's just an unfortunate reality. The more amenities that properties have and the more unique that they are, the more difficult it is to pursue an equity complaint. So it's just that can be an avenue that's very difficult, I think, to be successful at if attorneys or property owners are pursuing reductions, and that I think that can be frustrating for property owners, but unfortunately that's somewhat of the nature of the beast of equity or uniformity complaints.
And
I think it's important to note that many border review rules have kind of aligned with what's expected at PTAB in terms of the burden of proof, in that those equity and uniformity cases have a higher burden of proof that is clear and convincing evidence. And so I think that plays into an attorney's ability to be successful in that type of case. And I'm wondering if that is explicitly stated in each of your board review rules.
it is for Lake for sure. And I guess I can also add to the issue by saying the success rate in the last year or 2 to 3 years for equity has been probably less than 2% in all the equity appeals that we have received. So we do hold that bar very high.
Same in Kane, and we do state in our rules that it's got to be clear and convincing evidence. It kind of mirrors PTAB in that way.
In McHenry, we look for the same, and it's difficult.
Okay. Going on to the issue of the purchase price or the purchase price of the subject property. Can we talk a little about when there is a sale of the property in question? I guess what evidence do you look for, and what are some maybe red flags that can be raised when there is a sale of the purchase price? And I will start with Michelle.
Yeah, so the board would prefer to have supportive evidence to the purchase price. So, other sales, for like a typical overvaluation argument, let's say there's no sale to the subject. So kind of developing the evidence that way, and then the subject sale is, just kind of hones the final opinion of value, or what the market paid for that. We would like to see like MLS sheets of the sale or CoStar, how it was advertised, that details about that. Let's say with just the MLS, say there's going to be remarks and stuff in CoStar MLS that say if there are issues with the property or reasons why maybe it's sold under market value. So that's one of the things the board is going to look for. Red flags would be like, for instance, if the township assessor puts forth evidence that shows that if we take a single family home, every other home in the neighborhood that's similar sold, that subject sold for like $25,000 less. Well, why did that happen? So the board is going to be interested in understanding, was it an arm's length transaction? Is there other evidence that supports that purchase price for the subject? And again, the the township assessors will pull their evidence together and find out if there's reasons that that sale price shouldn't be accepted.
For us in Lake, the P-tax is also a critical ingredient. Closing statements are accepted. The P-tax can give us clues about the nature of the sale. And we also accept the listing information versus perhaps on a P-tax, it says it's an unadvertised sale, or
Right.
there are other compromising, elements that can be checked on a P-tax that would lead one to believe it's not necessarily your typical arm's length transaction.
I think that in McHenry, our goal is to follow the types of decisions that PTAB might make in regards to sale transactions. So it coming from a background of working for an attorney's office, I feel like there's lots of information out there about what PTAB will accept and what they won't accept in terms of a purchase price, and that's where we look to take our direction from also.
In DuPage County also, it's very similar to what Michelle and Maria said. MLS, transfer declarations, those are all going to be looked at.
Okay. And then in that related to that, will the board ever ever consider a PSA or a contract for sale that has not closed yet?
Yeah, so in Kane County, we will consider that. But like how long has something been under contract? What are the details about that? And it's just going to probably get a little bit less weight than like for instance, again, going back to like the residential or commercial, there's other closed evidence that's going to get weight, and then that kind of shows where things are going maybe, so it'll probably get a little less weight than other evidence.
We do not in Lake. We do not consider that.
In McHenry, I think it is, I can only speak for myself and not for the other two regular board members. It is something that I would consider, but I would definitely provide other evidence that supported the market value in terms of comparables or an appraisal or some other form.
I'm not a board member, so I won't be in the hearings to make that kind of determination. I think it would really just kind of depend on the situation and which board member you're dealing with.
Okay. Regarding property characteristics, how do your boards or the township assessor, I guess handle if there needs to be a correction to building size or other characteristics such as the number of units, and can these be addressed at a hearing in your boards of review?
So in Kane, the township assessors are the only ones that can make those changes, say that result in a property record card change. So we can't do it. It does come up often, well, not often. Every once in a while it'll come up in a hearing where the property record card is wrong, and for whatever reason the taxpayer hasn't worked that out with the township assessor beforehand, maybe because they think we can change it. I'm not sure. But if there's all kinds of evidence if there's enough evidence to show the board, say hypothetically, a single family home really has 2,500 square feet instead of 2,800 square feet, like the property record card shows, then it will be considered in the decision that the board makes. If there's enough evidence to support what the taxpayer is saying about a change or something that doesn't reflect in the property record card, they can argue that with the board, and it will be considered in how if the board lowers the assessment, they will definitely consider that in the way they formulate their decision.
In Lake, we defer to the assessor to let us know whether or not they feel a field visit is required before any change can be made. There are some assessors that are a bit more flexible. The board's policy does encourage the field visit concept, and we give enough indicators in our board rules on the blue card that goes out for the current, year's assessment and so on, to suggest that people first try to resolve something that's simple, that nature, prior to considering even appealing with us. And even if they get a correction in the property record card for whatever reason, bath count, square footage, fireplaces, many people sometimes still do appeal because they have other, cause and justification to have other elements of their value be, considered.
In McHenry, it is definitely the best idea to contact the assessor site visit in regards to discrepancies on square footage or other characteristics. And exactly like Maria indicated, so that may resolve any issue in regards to appeal. And if it doesn't, then still filing an appeal. But at the time of hearing, we will not change square footage. We do defer to the assessor and their process in terms of doing that.
Bridget, do you know?
Yes, DuPage County would be the same. You would want to contact the township and get your property record card fixed at their level. And if they need to do a field visit, get it worked out with them.
And then I guess to that just point, for the time that it comes up, do you guys defer to the property record card for the square footage allocation? Like what if the appraisal and this property record card differed? What would be?
I think we would go to the property. I don't know for sure. I'm pretty sure we'd go to the property record card. But if they can go to the township and get it worked out, we could then change the assessment.
Right. So just like everybody has said, it's definitely preferable. You have to go to the township assessor first and get all those changes made. However, if for some reason that's not done, in our live hearings, we will have the township assessor there. So it will be discussed back and forth, and if the township assessor agrees that something can be decided based on what the taxpayer is saying, we'll definitely take that into account, and that'll be part of the decision process.
In Lake County, there's always a debate between outside measurements and what that value comes out to be versus inside. And so depending on the approach in an appraisal, or let's say if it's a pro se filing by the property owner and they have their, drawings from when the house was built or any other, information that leads them to believe that it may be less than what the township has them on for. Again, the emphasis being placed on the difference between an outside measurement approach. We always defer to that with the assessor. However, again, we are willing to defer to the assessor if they see justification to make some change or have some other insights that they think, there could be cause for, considering something else other than what they have on the, currently on the property record card.
Speaking of township assessors, I'm going to jump a little to kind of their role because that is, I believe that is a unique aspect of the Collier counties, or at least that it differs from Cook County. And so some of you have already discussed that at live hearings, the assessor is present, or a representative of that township assessor is present at the hearings. So is it true that in all of your counties, the township assessor will always be present?
Yeah.
Okay.
The board
And then
expects that to back up whatever evidence they are trying to prove their side of the argument about. So if an assessor does not attend, they will get a call from our CCAO asking. It has happened in the past, but rarely. So there is that expectation to be the representative of your work on both sides, clearly.
And they typically submit evidence as well?
all the time.
Yeah, same with Kane. Yeah. They
They
submit
expect that.
strong evidence and they show up and they have a lot to say.
Yes, I know from experience that they are very active participants and do submit very strong evidence. They know the properties, they know the community, they know their comps, they know the property in question. I say that the township assessor is a strong participant in this. Is it common in your counties for the township to get any kind of appraisal um, for their evidence, or do they rely more on comparables?
I would say for our townships, it's mostly comparables. I think I've only ever seen them get an appraisal once.
Same.
Yeah, a couple of our township assessors are actually appraisers too. So sometimes, so you'll see their evidence come together in a strong manner, almost like an appraisal, but not an appraisal. And I have seen assessor actually bring a third party appraisal in, probably in the case where, a larger assessment figure has been argued for several years maybe, and they want to just bring that in or to refute maybe what they think is a pretty poor quality appraisal on, again, a property that has a really large assessment.
Uh,
Um,
in
Go ahead,
McHenry,
Rebecca. Sorry.
oh, I'm sorry. In McHenry, it is the case that township assessors will bring in an independent appraiser. Uh, More often it's commercial and industrial properties, but even on residential at times they'll do so.
And then what is the importance placed on a property owner's communication with the assessor prior to uh, with the assessor in this process, whether that is before the appeal, before the hearing, or even before an appeal is filed? I can start with Maria. Um,
Can you repeat that for me? Just
yes, what is the board's, I guess, what importance or if anything, if any, is placed on a property owner or their attorney having communications with the assessor prior to the board review hearing? And is there a distinction made between communicating prior to even an appeal being filed or communicating just between the appeal being filed and the hearing being held?
We don't have any bias for either issue of reaching out to the assessor or not. Again, I think it's an efficiency thing that we promote it in our literature and our rules and on the website and so on. We have a mechanism with the board. We call it a BR, which is a board recommendation. And so if there's going to be a change on the property record card, if it's a comps case even, that the appellant, whether it's for equity or sales or actually even, an appraisal they might have, and go visit their assessor, and the assessor sees justification for making a change, they can transmit that recommendation to the board. It's something we do electronically. So those values are given to us, requires two board members like a hearing concept to sign off on that. And then that gets put into the record. I can also say that many times, particularly more so on commercial cases or high value residential property, there can be a meeting of the minds in the form of an offer that's extended by the assessor. However, the attorney or appellant, if it's pro se, has the option, again, electronically, to accept that offer, or by not accepting, that kicks it for sure to a hearing mode to discuss. So the board at that juncture, if it goes to hearing, will make the decision. So it basically is saying it can leave the appellant vulnerable to an issue of discovery if we find out, or the assessor finds out, that there's more to be considered. So that I've had hearings where a decision by the board is made, an offer not accepted, and the board ends up going to a higher value than the offer. So that's a critical point in time for representation on an offer. to really reach out to a client and say, what do you think? Or here's my recommendation. And it does involve an amount of risk. But again, on the technical side of things, if an offer is accepted, like a BR, the board will just put that in the record. The case is closed if they've filed for the appeal anyway. And so we don't end up having the hearing often enough if it's done well in advance of the hearing. But many times attorneys and appellants will call in for their time slot if it's already been posted as on our hearing schedule, just to, call and double insurance, make sure that that did go in the record.
But I want to follow up on that, and then I'm going to get everyone else's take on the
Sure.
same issue. But because this has come up too, if there's been a BR submitted in Lake County or an offer accepted and that has been, transmitted, are the appellants still required to attend the hearing? Because there's this risk of like, if I don't attend the hearing, then it could just be, they could just not accept the BR or not accept the offer.
Well, the BR in our practice will always govern the decision. Unless again, something which really does not happen very often to suggest that something else is, overlooked, but they don't have to attend, but I think it is still wise to attend just to make sure that, what's inked is what's decided on. So unless there is a discrepancy, let's say in the typing in of values that potentially won't be discovered until all the hearings are done and the letter is issued, it's really wise to still call in and validate what the numbers are.
I just want to be clear here that sometimes when that recommendation is made at the board level, there will be no hearing scheduled.
Right.
So depending on where you're at in the process, there may not even be a hearing scheduled. So it's only a matter of if there is a hearing scheduled.
Mhm.
And I do know, and I don't know this intimately, but I do know that this works a little differently in Will, and we don't have a representative from Will County on the call. But I would highly recommend attending the hearing in Will to ensure that any type of agreement between the township and an attorney would get board approval.
And I'll go to Rebecca. How are the board view involvement on communications with the assessor, and then the same type of thing of if agreements are reached in advance of the hearing, how are those handled and expectations for appearing at hearings?
So in McHenry, unfortunately, there's no hard and fast rule in terms of communications with the individual township assessors. There are some township assessors who will, in fact, have discussions. And there are some townships that require filing regardless. It is really township assessor dependent. In terms of stipulations, the stipulations must be reviewed by the Board of Review and they can in fact be rejected. It depends on where, like you were talking about, sometimes there isn't even a hearing scheduled necessarily. If that's the case, notification will be received. It could behoove an attorney to attend when there's a stipulation to be certain that it's approved when there's a hearing scheduled, just to be certain. We have rejected stipulation offers that assessors have agreed upon this season.
There's one thing I want to add about attendance for attorneys in particular. If an attorney has signed on for an appeal and does not appear, we will dismiss the case. They have two options if they know they are not going to appear. And that would be to get a substitute. If it's somebody within their firm, a lot of the attorneys who do that, we know that they're, coexist. Sometimes it would be best if it's an unknown quantity in terms of relationship with the board to have a written letter identifying the attorney that you are having substitute for you. If it's somebody who is a single shop attorney, and have that sent to the board, and staff will transmit that to us. We will not let the appellant in particularly an attorney filed case attend to attempt to represent themselves and their ownership interest in a property, whether or not it's pro se or an LLC, corp, whatever it might be. That attorney has to be there or it will be dismissed. Or again, making arrangements ahead of time. The other option that the attorney has with us, because we do letters, if they're not going to get a substitute, they also need to transmit to our staff that they would request that the live hearing be converted to letter format. And so then, but that action on the part of the attorney to not lose the opportunity to have that case heard. So.
But then Maria, with the BRs, would
Mhm.
that still be the case? If there's a BR submitted in advance and a hearing's already scheduled, that's not, they
No,
don't risk dismissal if there's
because we consider the BR the anchor of what's
Okay.
already been established with the assessor.
I think that I just wanted that clarification
Sure.
because it's, the rule, like if you don't appear, it's dismissed. But what if I have this agreement already and I've signed it? Do I still need to attend or risk dismissal? And so I wanted to clarify that.
Just from an advisory standpoint, it's still good practice and policy, and most attorneys who are familiar with us still convey that to the board about not attending, even if they did get a BR or it's a PTAB rollover potentially and that sort of thing. Again, just a suggestion to make sure you do the follow through so your client gets what they are expecting.
Michelle, how was it handled in Kane? Oh, you're muted.
Thank you. A little bit different. So once the township's published and the time that the deadlines are put into place for filing an appeal, we don't have what Maria has at Lake. We have you have to file an appeal, and if you're going to talk with the township assessor and and you're going to come to an agreement, then that's going to be a stipulation. And that would be signed by both parties at some point after the appeal has been filed and maybe the date of the hearing has been set. That will come through to the Board of Review. However, our Board of Review, as the years have gone by, really want to see the supporting evidence for those stipulations, even though they're signed by both parties. They want to see how they developed that valuation, how they got there. Similar to some of the other counties, they sometimes won't. I've seen them not accept a signed stipulation, especially if there's no evidence involved, to support that. Our Several of our board members are licensed and working appraisers, and so they kind of know what's going on in our county with valuations. And if they see something that just does not make sense to them, they might not accept the stipulated amount. Our board recommends always that the attorney is there because you never know whether something is going to be accepted or not. The attorney should represent, and they might be asked questions about certain things in order for the board to come to the conclusion that they'll accept the stipulation. Sometimes, so that's that for like a stipulation. I know that Maria mentioned something about a board recommendation. I think what happens sometimes for Kane County, once the township is published, the appeal process starts, and maybe there's discussions between the two parties, but they don't come to a stipulated amount, a signed stipulation amount. The board will put forth a board recommendation just in their evidence. It's not anything like what Maria was talking about. There still is a full hearing and everything like that, but sometimes they'll put that forth in their evidence. And again, all parties should be there to talk about and argue their place.
And Bridget, how about DuPage County?
In DuPage County, I ask that everyone speak to their township assessor prior to appealing. I know a lot of times, like we've been talking about is there's still negotiations going on between the township and the appellant, and you're getting to your deadline, so the appeal is filed. Also, I believe once with like a lot of our townships, they'll start doing their evidence and they may call and say, okay, let's come to an agreement. Once a stipulation's been signed for DuPage County, the hearing is canceled. If a board member or the board members were ever going to reject a stipulation, I would reach out to that attorney and the township and let them know that the board has rejected the stipulation and that we will still be continuing on with the hearing.
Great, thank you. Um, so we are running short on time. I'm going to jump in just because it's unique as far as just really quickly roles of the intervener, because in the Collier counties, unlike Cook, the board's review or the supervisor assessment has to give the taxing bodies notice if there's a request of more than $100,000 in reduction, similar to a PTAB hearing. And so intervention is much more common in in outside of Cook at the board review level. So I think that that's just an important thing to point out that I've sometimes seen as an intervener counsel that attorneys might be surprised to have us at the table. So I guess in your counties, are taxpayers notified in advance if there is intervention by a taxing body?
In Lake, if the box is checked off that it is 100,000 or more in assessed value that's being requested, then yes.
I mean, but are then the taxpayer notified that like someone has filed and that someone has filed a request to intervene?
In DuPage County, I do not reach out to let anyone know that an intervener has been filed.
It's not
Okay.
up to the board to let them know. It's up to the
Okay.
appellant, to inform the taxpayer in that scenario. And that's in our board rules.
Okay.
Right.
Yeah.
I'm not certain in McHenry about what their policy is in terms of notification. I think that that was actually potentially changing. So any attorney would want to be sure that they were aware of what to expect.
Same with Kane, like they they're they are required if it's over $100,000. So the taxpayer and their attorney would know that that can happen. Although we do have access to our evidence online, so 5 days prior to the hearing, the township assessors will upload their evidence, and anybody can look for that. And then interveners might do that too. And our interveners, they speak at the hearing. Typically, the township assessor and the appellant will speak first, but the intervener will also have their time.
We do that too in Lake County. We consider the role of an intervener to be critical because they're representing, inherently the public interest beyond the immediate two parties to the appeal. So yes, that involvement and additional set of eyes and review. And as some of you know who do function as interveners, very often an appraisal may be, entertained that's submitted by an intervener for high value commercial properties and such. So there's a lot to be said about what interveners can do in the process so that it doesn't solely rest on what the Board of Review does.
And in McHenry, it is true that any stipulation must be signed off on by the intervener as well.
So then dovetail off that, is signature of a stipulation by the intervener required in any of the other counties?
It's not required in Kane.
I can't speak for all, residential and commercial. I think it's a little nuanced. I think the key point here is for particularly high value ones, it's best that it is signed off by interveners. But my understanding, and I could be wrong on this because I didn't really ask our two chief appraisers who deal with the stipulations, whether it's residential or commercial. There are times when we leave that decision, I believe, up to the intervener, because it's really rests on how far they want to take their role in the process to ensure, again, within a quad or where they anticipate that decision is going to be, moving forward, or if it's rolling back into time, where there's still a PTAB that's lingering out there. So I think it's best insurance too for the interveners and their constituents representing the public interest that they do sign it. But I don't know that we really say it's mandatory at Lake County.
And then Bridget with DuPage.
No, it's not required in DuPage County.
Okay. I guess so we're coming up on time already. So I guess final thoughts, I guess, would be if there's any advice or things that attorneys should be aware of in your counties that you see would be would help the board be more efficient or helpful, or things you've seen in the past that, could be improved on. Any like quick one little thing that has come up in the last couple of years that you've always thought would be helpful or you've seen in the best appeals?
I'll take that first, if that's okay. One of the interesting things for Lake right now is sort of this duality of operating systems for pulling grids for comparables. So we have 18 townships, 6 townships, a third of our townships have opted to use a different system. We've got Tyler for the county, which got implemented maybe about 5-6 years ago. And 6 townships have gone with a system called IMS. So in our scenario, the county database for those 6 townships is not updated. So it's a serious flaw to not really pay attention to our board rules. We do direct everyone in our rules and online and smart file for doing the digital inputting of, the application, that if you are, dealing with these 6 townships as, as your client, you need to go to that township, extract the grid, and basically insert it as a document as part of your filing. What's happening now is we're kind of in a 4 to 5 year scenario of that happening. So there was a time when assessors were accommodating in the transition period and gridding the appellant comps. We're at a point now where we've broadcast that news in enough places. So the expectation is if you are going to, in those 6 townships, not provide the right grids, we will consider that pretty much a no change as insufficient evidence, unless there's some other ancillary evidence that's, compelling to, that's been submitted in appraisal or something like that. So just beware in our county, we do have that duality of information sources. So
That's a great thing to know.
yes.
I would also say for Kane County, we have heard several times in the past that Cook will lower assessments based on vacancy for commercial properties. And I don't know about the other collar counties, but we need supporting evidence. Like vacancy is kind of like a secondary piece of evidence. So it's not going to behoove an attorney to come in with just vacancy.
Yeah, I didn't get to the vacancy question earlier because we ran out of time, so that's a great thing to point out. Thank you.
And if I can add something to my comment about evidence submitted, for any of the townships, we want grids of comps cases, for sure. We do not accept evidence in the form of MLS listing sheets for the 4 comps that you're saying are to be scrutinized against, the subject being considered. It has to be gridded information. Some attorneys or individuals may choose to, and that's pro se appeals as well, create their own Excel spreadsheet. And they're only cherry picking the select elements. That too does not qualify as sufficient evidence. It has to be gridded in our system or in the IMS system for comps cases.
It's true that in McHenry, the comparables must be gridded. And oftentimes attorneys on commercial or industrial complaints will not complete grids. And we did make a change this year to our rules that we would no longer consider information that wasn't, if it was based on comparable sales or assessments, a grid must be completed for comparables to be considered.
Bridget, anything unique in DuPage that would be helpful for the efficiency of the board review?
Well, I mean, we don't have that same rule with the grids. We accept the evidence that's provided to us and the board members look at it as is. I don't know if anything is different. Well, we are moving towards e-filing. Our smart files should be up and running in the next few years. So as of today, we're still very reliant on paper appeals that are being mailed into us. So that will be probably the next big change for DuPage County is now moving into smart files and not having to have 2 copies of everything sent to us. So we're happy to announce that.
Yeah. Well, great. Thank you all so much. I don't know if we have any questions, Jesse. I haven't seen any questions in the question box. So, thank you also. Oh my God, one just popped up. I think we need clarification on this. Maria, you indicated about a licensed attorney from the same firm, attending in lieu of the attorney that filed under the same name of the firm. I think you said that was okay if they were from the same firm, but if like a solo practitioner is having another attorney appear on behalf of them, they need to it would behoove them to give you guys a heads up that,
Correct.
I'm covering for Sam Smith,
Correct.
because we're not from the same firm. But from my firm, if another attorney from my firm is covering,
Yes.
that is okay and doesn't need additional evidence, and
Right.
that's allowed.
Right, because the attorney, while the attorney is the filer of a multi-attorney firm, it's essentially the firm that is the representative, technically. So we wouldn't want another party from a different firm to represent that case. That would be new representation. And that would require a change formally prior to a hearing with the board.
Okay, but the same firm is fine. Okay, I just
Yes.
wanted to get clear. It looked like
Mhm.
there was some confusion on that, so I was just getting clarification.
Absolutely.
Awesome. And then there's another question that said Lake would formally decide the case before them if the representative didn't appear. Did this change for 2025 and now the appeal will be dismissed?
We've gotten stricter about it, yes.
Yes. Yeah. Okay. Okay. And with that, I don't see any additional questions popping up that haven't been answered. So thank you all for participating today. This was a great discussion. I appreciate it so much. As a reminder to everyone, there are materials in the chat that you can download, and you need to complete your evaluation at the end, the evaluation survey at the end of this, in order to get your MCLE credit. And you have to be signed in under your own unique registration link to receive that MCLE credit. So thank you all so much, and I am sure I will be seeing you at hearings.
Sounds good. Thank you.